which you use in cavity means you don't swallow them, right? So sublingual, buccal, troches, lozenges, dental cone, mouth dissolved tablets, right? Okay, state two excipients with giving one example for each used to prepare the coating material of tablet, right? So a film former, right? Cellulose acetate phthalate, alloying substances which is like a binding thing for the coating material. Polyethylene glycol, plasticizer like castor oil, surfactant, opacants, coloring agents, sweeteners, flavoring agents, lozenges. These are the things we can add for a coating material, right? So this process is might be too much for you all. So if you all like, you can see, right? So differentiate wet and dry granulation. In wet granulation, we use a binder solution. In dry granulation, we only use a binder powder, no liquid, right? So it's usually mixing, wet massing, drying, sieving. This is mixing, and once you mix the binder, you make them into compact and then you mill them, right? And so here, because you use liquid or any water, this is more suitable for moisture stable drugs. This is more moisture or heat sensitive drugs. You can use this because in this stage you will never come across with water, right? More time consuming, expensive, fast, and more economical compared to a wet granulation, right? So this one you should know briefly describe following tablet excipients in the terms of functionality, disintegrants, binders, and anti-adherents, right? So disintegrants, they ensure that the tablet, when in contact with a liquid, breaks up to small fragments, which promotes rapid drug dissolution. Form large surface area to the dissolution, two steps in disintegration process. The liquid wets the solid and penetrates the pores, and tablets break into small fragments, right? So binder is added to the drug filament mixture to ensure that granules and tablets can be formed with the required mechanical strength, and binders can be added to a powder in different ways and as a dry powder with other ingredients before wet agglomeration, and binders can be added to a powder in different ways and as a solution which is used as agglomeration, liquid in wet agglomeration solution binder, and as a dry powder with other ingredients before compaction, which is a dry bound, right? Anti-adherents, the answer is not given. Anti-adherent is usually given for a tablet to not mix up with the punches, right? Punch faces and make them free flowing with the tableting machine, right? And did you all write answer for this question? Huh? Did you all finish this question?
1.5.
1.5, yes.
I just blew. I don't think I wrote that correct on this.
Forms. In your pharmaceutics, the fourth or fifth module dosage form. Last, I will be doing about plasma drug concentration versus time graph, which also important in your biopharmaceutics and pharmacology. I hope you remember this graph. But the common thing is for the immediate release, but the question I asked today is for a control release. That's okay, that's a bit hard, but I hope you all know about the immediate release. Is that okay? Shall I close? Okay, here we go for the general offenses. So the general offenses, um, every person who, being a person acting under the authority of this act, discloses any information obtained by him in or in connection with the exercise of his powers or discharging his function under this act to any person for any purpose other than the purpose for which he is authorized to disclose such information, which means you can't disclose. For example, okay, if someone is a member of chairman or member of these committees and the divisions, you can't disclose any informations to the general public or your colleague or your friends or family, right? Unless it's given by the act that you can disclose. For example, in a court case or something where you can talk about it. Other than that, you can't talk about it to anyone, and obstructs without any justifiable or lawful basis any person acting in exercise of his power under this act or any regulation made thereunder. So obstructing, right? And being a person acting under the authority of this act behaves or conducts himself in a vexatious or proactive manner while exercising or discharging any power or function under this act, and who fails to furnish any return or information in compliance with any requirement imposed on him under this act, knowingly makes any false statement in any return or information furnished by him. And punishment, right? So shall be guilty of offense under this act every person who contravenes any of the provisions of this act or any regulation made thereunder shall be guilty of any offense and shall on conviction can be liable where the nature of offense involves injury to the health of the public to a fine not exceeding 200,000 rupees, which is 2 lakhs, right? Or imprisonment for term not exceeding 3 years or both, right? If it's causes a injury to health, mm, right? To the public, health of the public. For unauthorized use of state logo, right? So the government logo or other mark which indicates medicine, medical device, borderline property to be state property. So for such offenses to a fine not exceeding 100 rupees, right? 1 lakh, or imprisonment not exceeding 3 years or both, right? For carrying on a pharmacy without obtaining the license, right? Which a common offense many people do, to a fine not exceeding 100 rupees or 1 lakhs or to imprisonment term not exceeding 3 years or both, right? So these are the major offenses. For any other offense, for the first offense to a fine not exceeding 100 rupees or to a imprisonment for a term not exceeding 3 months or both such fine and imprisonment. For second or subsequent offense to a fine not exceeding 200 rupees or imprisonment for term not exceeding 6 months or both, right? And also to publish an apology in addition to the punishment, the fine or a jail punishment mentioned in paragraph ABC, these three, right? So if you do any of this guilty to the general public in one Sinhala Tamil English newspaper each, right? One Sinhala, one Tamil, and one English. Circulating in Sri Lanka substantially in the size of 10 inches into 10 inches in front page to effect that he shall not repeat the offense. So, other than for the paying of these penalties and everything, they should publish a newspaper advertisement stating that they won't perform that type of offense anymore. So, where a person convicted of an offense under this act or any regulation made thereunder is convicted of a second or subsequent offense of a like or similar nature under this act or regulation made thereunder, the court convicting him for the second or subsequent offense may cause the name and address of the person convicted and the offense and the punishment imposed for such offense to be published in such newspaper or in such other manner as the court may direct and recover the cost of publication from the person convicted as if it were a fine imprisonment on him. The offense sometimes may cancel any license or registration issued to the person convicted for the manufacture, importation, sale, distribution of any medicine, medical device, or borderline product under this act or any other law in the form and inform the relevant licensing authority accordingly. Where a person is convicted of any offense under this act or regulation made thereunder relating to the storage, sale, distribution, and transportation of any illegal, unregistered, counterfeit, and smuggled medicine, medical device, or borderline product which is marketed, state logo, or any other marking indicating that such medicine, medical device, or borderline product is a state property, the magistrate may, in addition to the punishment provided under this act, upon application made by an authorized officer for closure of such premises and order the closure of such premises, discontinuance of trade or business carried there, right? So in case if you use as a state logo, maybe that can be again given you a punishment like stopping the business, right? So that application, so that punishment is upon the application by the authorized officer. So, where such person fails to comply with the order issued under this section, the magistrate shall forthwith issue an order to the fiscal of such court requiring and authorizing such fiscal to closure such punishment and discontinue the trade or business carried on therein before the date specified in order, not being a date earlier than 3 years and not later than 7 days from the date of issue of such order. And every person who commits an offense under this act or any regulation made thereunder may be arrested without a warrant, and every offense under this act or regulation made thereunder shall be triable by a magistrate court. So, without a warrant, the person can be arrested. So, if the person who got arrested, right, under this court, so and on giving to the prosecution not less than 3 days notice of his intention, be entitled to have any other persons whom he charges as the actual offender brought before court, and if after commission of the offense has been proved, the accused proves to the satisfaction of the court that the commission of offense was due to the act or default of such other person may be convicted the offense, and if the accused further proves he has used all the due diligence to enforce the provisions of this act, he shall be acquitted of the offense. So, because you have found guilty of something, and within 3 date of your charge, you can You can just make a statement, okay, I'm not the actual offender, some other person, so that person also will be taken to the custody. And in court you have to prove that you're innocent and the other person is the one who really convicted that offense, right? So in that case, the other person who now got accused will get the punishment, and you have to prove you have innocent, right? So in case if you fail to prove you innocent, both of you will get the punishment. Where an accused seeks to avail himself of the provisions of subsection, the prosecution, as well as the person whom the accused charges with being the actual offender, shall have the right to cross examine him if he gives evidence, and any witness called by him in support of his pleas, and to call evidence in rebuttal. So the court may make such order as it thinks fit for the payment of cost by any party to proceeding to any other parties thereto. So the defense in prosecution for the offense of sale of any medicine, medical device, or borderline product contrary to provision of this act, or any regulation made thereunder subject to subsection 2, shall be defense for the accused that he purchased the medicine, medical device, or borderline product in a package and sold it in the same package and in the same condition that it was at the time he purchased it, right? So that's what I said. Even if you purchase a product and you sell it, and the product problem is with the product, maybe if you can prove that you actually sold it in the original package and you didn't make any changes in the storage condition as you purchased, then yes, you have a defense. And he could not have with reasonable diligence ascertained that the sale of medicine, medical device, or borderline product would be in contravention of the act or any regulation made thereunder. The defense specified in subsection 1 shall not be available to accused unless he has within 30 days of detection of the offense informed in writing to the authorized officer detecting the offense of his intention to avail himself of such defense, and the name and address of person from whom he purchased the medicine, medical device, or borderline product, and the date purchased. For the purpose of this act and of any regulation made thereunder, any medicine, medical device, or borderline product found kept exhibited in any shop, other place commonly used for sale of articles shall be presumed until the contrary is proved to be intended for sale. Any substance capable of being used in the composition or preparation of any medicine, medical device, or borderline product which is found in the premises and used in preparation shall be presumed until the contrary is proved to be intended for use in the same composition or preparation of that medicine, medical device, or borderline product. So, if the prosecution for the offense of manufacturing a medicine is adulterated, it is established that such medicine was adulterated with the addition of any other substance that accused had in his possession or premises such other substance. So it shall be pursued until the contrary is proved that such medicine was adulterated by the addition of that other substance. Where any package containing any medicine, medical device, or borderline product has on or upon the name and address purporting to be the name as the address of the person who manufactured or packed it, it shall be presumed until the contrary is proved that the medicine, medical device, or borderline product was manufactured or packaged, as the case may be, by the person whose name or address appears on the package. So, if any offense committed by the body of the persons, we are offense under this act, or any regulation made thereunder is committed by body of a person, and if that body person is a body corporate, every person who at the time of commission of the offense was director, general manager, secretary, or other similar officer of the body, or if the body is not a body corporate, every person who at the time of commission of the offense was member of the body shall be deemed to be guilty of that offense, unless he proved that such offense was committed without his consent or concurrence, and that he exercised all due diligence to prevent the commission of such offense as he ought to have exercised in the circumstances having regard the nature of his functions. Right? For example, like there is no escape for the director if it's a corporate, because everything finally signed by the director and given approval. So there is always no um, right proving for the director, because people who actually in this position, right? So it's very difficult for them to get away from this type of punishments, right? So that is for the offenses and defense. So the part 5 is about the general again, who is the approve analyst and about the approve analyst, right? So a government analyst shall be the approved analyst. So who are the government analysts? NMQAL, right? National Medicine Quality Assurance Laboratory, Medical Research Institute, Mri Sri Lanka, can be a additional approved analyst, right? And notwithstanding the provisions of subsection 1, and the minister may approve any other laboratory or institution recommended by the authority to be an additional approved analyst, and that notification should be published in the Gazette. No person, laboratory, or institution shall be approved as an additional approved analyst if that person, the laboratory, or the institution does not possess the prescribed qualification or facilities, as the case may be, right? And if that person engaged directly or indirectly in any trade or business connected with the manufacture, importation, sale, or distribution of medicine, medical devices, or borderline product, right? For example, you are taking an additional approved analyst who already manufactures and distributes a medicine. So, if you send another medicine for a testing to the same manufacturing company, maybe that can be a competitive organization or something. So, you can get a false report sometimes, right? So, therefore, anyone who already involved in a trade cannot be function as an additional approved analyst, right? In the absence of evidence to the contrary, a document purporting to be report or certificate signed by the approved analyst or additional approved analyst upon matter submitted to him for analysis or examination shall be sufficient evidence of the facts stated therein. When the party against whom the report or certificate referred to in subsection 1 is produced requests the approved analyst or additional approved analyst to summoned as a witness, and the court shall summon him upon that party depositioning in court the expenses of summoning him, including such fees as may be prescribed payable to him, and shall examine him as witness. The report or the certificate refers to in subsection 1 shall not be received in evidence unless the party intending to procedure it has given the party against whom it was intended to be produced a copy of report or the certificate and reasonable notice of his intention to produce it, Every court shall give priority to the trial of any person charged with or indicated for any offense that is under this act, and to hearing of any appeal from the conviction of any such offense and sentence imposed on such conviction. So the provision of this act and any regulation made thereunder relating to medical medicine, which exercise excisable articles within the meaning of excise ordinance shall be in addition to and not in subsection substitution for the provisions of the ordinance. So the provisions of custom ordinance shall apply for the purpose of enforcement and the prevention and punishment of contraventions or attempted contraventions of the provisions of this act and any regulation made thereunder relating to the importation of any medicine, medical device, or borderline product. Yeah. So part 6. So any rules made should be gazetted, right? And regulation can be made by the minister, right? So the minister can make regulation on declaring that any medicine, medical device, or borderline product, or the class of medicine, medical device, or borderline product is adulterated. So if any prescribed substances or class of substance is present or has been added to or extracted from or omitted in that medicine, medical device, or borderline product. So minister again can make rules on these things, right? Declaring anything as these products safe for general use or not safe. Pricing these products, make regulation on labeling and packaging and offering, exposing and advertising, prescribing the size, dimension, pill, and other specification of packaging, right? Or the use of any substance as an ingredient in medicine, medical device, or borderline product to prevent the user or purchaser from being deceived or misled as to its quality, character, value, composition, or to prevent injury to the health of the user or purchaser. And minister can make regulations on standard of composition, strength, potency, purity, quality, and other property, right? The method of preparation, manufacture, preservation, packaging, storing, testing, right? So, a person to whom the circumstances in which the terms and conditions subject to which licenses and registration under this act may be granted or refused, and the manner and mode in which applications for license and registration under this act may be made and dealt with. So, regulation on furnishing information and maintaining the record, and making rules for the registration and regulation of pharmacies and drugstores, any condition for storage and transport, disposal of medicine, right? And investigational medicinal product, and specification for recalling procedure of medicine. So recalling procedure is already given in WHO, but the minister also can make regulation. And the conditions relating to importers and market authorizer holders, and procedure for parallel imports, right, for non-commercial use, and forms to be used in registration, renewal, and licensing, and prohibition and restrictions relating to the sale and transport, prescribing, right, the minister can make regulation in prescribing, and the distribution and condition of distribution of sample medicines to medical device or investigational products, and the mode and manner in which any medicine, medical device, borderline product shall be registered, terms and conditions, right? Appeal committee function, shelf life of manufactured products, procedure to follow followed in medical evaluation committee, medical evaluations committee, medical borderline product evaluation committee and their functions, and the procedures to be followed in MEC, MDEC, and BPC, and review and revision of guidelines formulated under this Act, procedures, and evaluation of advertisements and promotional materials of manufacturers, importers, and distributors, and regulation and promotional activities pertaining to medicine, any other matters, right? So every regulation made by the minister shall be published in Gazette, right? And every regulation made by the minister shall not later than 3 months after publication in the Gazette be brought before Parliament for approval. And any regulation which is not approved shall be deemed to be rescinded and from the date of such disapproval, but without prejudice to anything previously done thereunder. So any notification of date of such disapproval shall be published in Gazette. So institutions of proceedings. So a prosecution for an offence under this act, so any regulation made thereunder shall not be instituted except by authorized officer and after expiration period of 3 months from the date of detection of that offence, where sample is analyzed after the expiration period of 1 month from the date of receipt of analyst report, right? And no civil or criminal proceeding shall be instituted against person for any act which is in good faith done for purported to be done by him under this act or any regulation made thereunder, right? So this is repels and transitional provisions. So CDD Act, which was on action till 2015, right? So this is like whatever the agreements or whatever the rules, everything, the division, subdivision attached to the CDDA will be transitional to the NMRA, right? So this is about that thing, right? This is not important. So everything is converted, right? So all the agreements entered into the repelled act, like the CDD Act, will be subsisting on the day immediately preceding appointed date shall with effect from appointed day. The contracts and agreements entered into this act with on behalf of the authority may be enforced accordingly, right? So this is about the act, right? The properties declarations, right? And yeah, we are almost finished, right? So now we have the part 8 interpretation. As I mentioned, whatever given here is the definitions, right? So you can go through it if you have an doubt. So bioequivalence test, biowaiver test, right? Biowaiver test, borderline products, cosmetics. What is CDD Act? And fraudulently, right? Generic medicine means good distribution, manufacturing, pharmacy practices, right? In sanitary condition, labeling, right? Everything, every definition is given here, right? In the act. So here I have given you the summary, right? So yeah, before you go to the exam, the summary is 20 pages. So it's contain all the details about medicines evaluation on offenses, application for registering medicine, cancellation, right? And function of manufacturing regulatory division, pricing, regulations for pharmacies, authorized officer, power of authorized officer, general offenses, punishment, defense, rules and regulations, interpretation, right? So maybe I recommend you all to read this one if you are going for an exam rather than checking the entire these things, right? So this is the website. So, so this is the regulation of pharmacies. What does NMR Act say? Yes. So this is the regulation of pharmacies. So we have already read. So requirement to comply with offenses. For example, transport, you need to take transport license. Retail, you need to take retail license, right? So this is the application form we've checked. So we have the next unit, we will be discussing about the regulation. So what we discussed is in the presentation, right? So here a small brief introduction about the Parliament Acts that's relevant to practice of pharmacy. So what is forensic pharmacy is what we are learning, right? Rules and regulations of pharmacy, pharmacy practice, and also relating to drugs and pharmaceuticals. It is important to be knowledgeable about the laws and interpretations of laws and statutes. So, what are the laws available? So, Act is Parliament makes law. Ordinance is refers mostly legislation passed during the British rule, right? So, yeah, this is not relevant. So, these are the important things we have, right? So we have a National Medicines Regulatory Authority, Act number 1, Act number 5, and this is the regulation, right? So this is different act, this is the regulation, right? And so we have Constitution, Policy, Law, Act, Regulation, Rules, right? NMRA. So this is Poisons, Opium, Dangerous Drugs Ordinance. We will be learning. CDDA Act, it is repelled now. So other conventions again, illicit traffic, narcotic drugs, psychotropic substances, precursor control, National Dangerous Drug Control Board Act is there, Ayurveda Act is there, Consumer Wear Authority is there. So these things, in case if you have a problem or something, you have to refer these things, right? Food Act is there, amendments are there, medical ordinance. This is your unit one. I didn't still touch because you need more about the NMR Act than the medical ordinance. So Shop and Office Employees Act, National Environmental Act. So there are Intellectual Property Act, right? So this is the important part, how these are relevant to you, right? NMRA Act. So pharmacists are responsible for activities related to medical products, manufacture, import, sale, advertising, regulated under this act. How poisons, opium, dangerous drug, pharmacists are custodians of poisons, opium, and dangerous drugs, right? So you can't give any other persons to handle the poisons, opium, and dangerous drug. Cosmetic Devices Drugs Act. Pharmacists are responsible for activities related to drug and devices. Some cosmetics are used for medical purposes, right? So illicit traffic in narcotic drugs and psychotropic, because pharmacists are custodians of narcotics and psychotropics used for the medical purposes. And Precursor Control Authority, because some chemicals used for medical purposes which are handled by pharmacists can also be used as precursor to manufacture illicit drugs, right? And National Dangerous Drug Control Board, pharmacists have the unique knowledge, skill, and responsibility for assuming an important role in prevention of substances abuse and educating people about their negative effects. Ayurveda Act, because pharmacists as health professionals should be aware of these commonly used indigenous medical system. And consumer affair, the products handled by pharmacists are also consumer products. So some areas in this act are applicable. Food Act regulation. So pharmacies should aware of food regulation because certain food items are sold and distributed in pharmacies, and pharmacists have responsibility in advertising patients about the food they take. Medical ordinance, the pharmacist should be aware of this law that governs pharmacists as the professions and also law that related to other related professions. Shop and Office Employee Act, because they are employees, especially about regulation of employing working hours and remunerations, right? And National Environmental Act, because it's the their activities such as disposal of expired and unused medicine and medical pharmaceutical waste and manufacturing of pharmaceuticals. And Intellectual Property Act, patent protection is particularly important for pharmaceutical industry. So as the development of drug is very expensive and time consuming, pharmaceutical companies require sufficient protection to recover their investment and earn profits. These profits will in turn, would allow financial further research and development, right? So, this is a small summary. You don't need these things. So, in all, we have just completed the unit 2. So, I will be starting up unit 3, which is about the regulations of NMRA Act, right? About the advertising, patients' rights, and everything, right? So we have the regulation, right? So because under the regulation, I want to teach everything, right? So just I will be going through the important registration of medicines and all, right? Uh, so I want to wind up the class now since we have time, right? So I wanted you all to attend the second question, right? This is something common you can get. So don't attend this question. Okay. So there are these two are simple questions, and Yes. Again, a half an hour will be enough for you all to do, right? So, yeah, we are almost near to the last sessions because only NMRA Act take 4 weeks. The regulation and the remaining will take one class or so. And the last two units, Food Act and the Consumer Affairs, that two lessons will be finished in one class. So maybe by this month, we can finish the forensic pharmacy and communication skill, right? So in about 2 months, the overall class will be finished. And practical, yes, until they arrange the gases, I won't be able to do the practical, right? So yeah, so we'll start doing the questions parallelly, right? So I'll give you all a half an hour time, 30 minutes. So by 12:15 to 12, sorry, by 2:15 to 3:15 to 3:20, try to complete this. We'll discuss the answers and we'll wind up, right?